Good morning, my lady, my lords.
Good morning, Mr. Asplin.
I appear today with Mr. Cribb on behalf of the appellants, stroke applicants who are referred to as the bank, if I may.
I can't see Mr. Cribb. Yes, maybe he can just move a little sideways. And we have Mr. Sondor, do we, on the screen?
I believe we do.
Yes, good morning, Mr. Sondor.
Yes. Good morning, Your Lordship.
Can you hear us okay?
Yes, I do, Your Lordship.
I think if we can turn the volume up a little bit in the court, that would be helpful, because although we can just about hear you, we can't hear you very clearly.
I'll try to speak louder.
Oh, okay, lovely, if you could do that. Good. Now, Mr. Houseman, you probably haven't had an opportunity to consider with Mr. Sebastian and Mr. Sondor how you're going to divide your time. That may not matter, but what have you had an opportunity to do?
I've had an opportunity for a brief chat with Mr. Sebastian, who's obviously here in the role as advocate on behalf of the Attorney General.
Yes.
And he's free to say what he feels he might see his role as.
Well, he would probably go after the parties.
That was the thinking, that's what I was coming to. So I all things being equal and subject to what the court would like to hear, I was figuring I would just go first, present the application on behalf of the bank, and then if the court wishes to hear from RCA through the screen, the court shall do so. Mr. Sebastian will assist the court in his appointed capacity.
Right. Okay. There are two questions I've got for everybody. The first is what happened to the appeal on the 29th of January 25 in Leningrad, in St. Petersburg, because I believe there was an appeal by UniCredit against the decision of the court, and I believe that if the appeal was dismissed on that occasion, the 14 days for compliance with the order ran from the 29th of January 25. Is that correct?
May I check? I've neglected to check on the factual position.
My Lord,
Yes, Mr. Sondor.
Could you update?
Yes, well, two different fields. One is the Russian ASI order, and as we understand, UniCredit has appealed it to the Cassation Court, and the other is the appeal on the merits of the case that relates to the bank guarantee. And that appeal has been deferred to the 19th of February, deferring the coming into force of the judgment of the Russian court on the merits.
So the appeal on the merits has been postponed until the 19th of February in Russia. Does that mean,
Yes, my Lord.
does that mean that the order of the St. Petersburg court has not, hang on a second, I'm afraid I've got a technical problem with my keyboard. To the 19th of February. What about the cassation appeal?
Yeah, it hasn't been yet accepted by the court in terms of, a hearing hasn't been listed as far as I'm aware, but that does not influence that this court order is enforceable immediately.
So I thought the court order was only enforceable 14 days after the dismissal of the merits appeal. Is that wrong?
No, my lord. The 14 days are given to the UniCredit to comply with the Russian ASI order. That's the 14 days referred to in the Russian anti-siege injunctions order.
And when did that start?
Well, this might be of a question within the parties. to lapse on the moment the full court order, the judgment, ASI judgment, has been published. So that would mean that I open that ruling. It's the ruling of the 28th December, and arguably, and we have already agreed in the correspondence with the UniCredit that any non-business days are not included in today's 14 days calendar because of the Russian procedural rules. And in Russia, most half of the January has been non-working days. So there is no dispute between the parties that the UniCredit has been in some way of a delay, and there is a further agreement in the bundle that states that if this application is unsuccessful, then RCA agrees that any further applications that UniCredit might make, given though after the time that has been given to UniCredit to comply with the Russian order had elapsed, RCA would not deem that as a breach of the Russian ASI court order that is made in writing.
Right.
I hope that helpful.
Okay, well, let's come back to that later. That's very helpful. Mr. Hausman, you can come back on that. The second question we asked by email, I think, from the court to the parties yesterday was a twofold question that we'd like to hear submissions on. One is, what would be the legal effect of a finding that UniCredit was not acting of its own volition, or using tendentious perhaps words, was acting under duress? What would be the effect of that? And secondly, in what circumstances can a court accede to an application that has been necessitated by a change of circumstances that is avowedly a move from one party, in this case RSA, a move by one party, RSA, from respecting the orders of the English court to a refusal to respect the orders of the English court? And what we want to know is, what is the legal effect of that change of circumstances? And I'm hoping that we will get answers to those questions from all parties in the course of their submissions. I don't want to disrupt the course of anybody's submissions, but I hope you got that message. And you got it too, Mr. Sondor. Good. Excellent. Good. Well then, Mr. Hausman, off you go. It appears that the 14 days is not really important. Nobody is suggesting that you're in breach of the order by being here today. You are, in fact, apparently complying with the Russian court's order.
Well, on that, so far,
Well, so far.
is the safest way to put that.
Yes.
And as a matter of private agreement between RCA and my client, one cannot therefore exclude what we would call the court risk, the Russian court risk, that it takes a different view from RCA. Now, that you might regard that as unlikely, but that is there. And then the wrinkle in that factual story is obviously the later letter from ELWI, as I will call them, ELWI, RCA's Russian legal representatives, which at that paragraph 26 suggested that things might not be as straightforward as being previously suggested in terms of compliance. But we'll come back to that, no doubt, when we look at the risk, as I would call it. On the second aspect, I have an apology in the sense that I'm currently part heard in a 10-day arbitration. Today is day 7. I got dispensation from my solicitors very kindly to attend.
So I heard, Mr. Hausman.
I didn't know if you had or not, and I wasn't going to make anything of it. And certainly this hearing has to last as long as this hearing has to last. But it does explain why you didn't get anything in writing from us on that two-pronged inquiry yesterday.
Mr. Cribb is here.
He is, but we are where we are, as it were. I fully intend.
When do you have to leave, as it were?
Whenever my lady and my lords release me, is the short answer.
Well, we're pretty indulgent these days. I agree that we used in the 30 years ago, if the Court of Appeal said you had to sit there looking at us, then you had to sit there looking at us. But nowadays, if you had to leave, you have to leave, and Mr. Cribb will hold the fort, I'm sure, for your clients.
Well, that's good to hear, and would be good for him too. I'm not hung up on the difference between a half refresher and a full refresher, no refresher today, I should say, in arbitration. It's not about that at all.
We regard this case as important.
Absolutely.
And we would like to hear your submissions. But if you need to go after that, it will be up to you.
Very well, I will take that course. There are juniors who are calling witnesses who I will re-examine, so there's a slight wrinkle, but that's been explained to the panel. But there we are. I only mention that because you didn't get something in writing from us.
No, don't worry about
it. I fully intend to deal with that. The way I was going to address the court, subject always to what the court wants to hear, is under 5 broad headings. First of all, an outline of what I regard as the big points. And in some sense, that's cutting straight to the protein, because we're better off just getting this out, what the court analysis is. So I was going to go through that, and in the course of that, I was hopefully going to deal with that 2-pronged inquiry that the court had sent about volition on the one hand, and what we might call assisting a contemnor, if that was the perception or the concern on the other hand. They are related points. So that will be outline, as it were, or protein, if you prefer. Then some background, but I sense the court is pretty familiar with how we ended up here today, but there's a couple of points to highlight in that, including the risk, as I've called it.
Actually, there's one question I didn't ask that I want to ask, which is I studied the Supreme Court judgment with a view to understanding how you happen to have a speedy trial before Sir Nigel Tier at the same time as an application contesting the jurisdiction made by RSA, all on the same day, which led to the order that we're dealing with being a final order upheld by the Supreme Court. Nothing could be more final than a final order upheld by the Supreme Court. But had it taken a different course and nobody had written the word speedy trial, it would be an interlocutory order, maybe still upheld by the Supreme Court, but if it were an interlocutory order, it would have been open to UniCredit to discontinue the proceedings, and thereby the order would fall. And I just wanted to make sure that I understood properly the procedure that had led to the speedy trial, and therefore the final order being a final order which is said, or could be said, to be in a different category from an interlocutory order. You understand what I'm
I do, absolutely, and my Lord has summarised it very well. The basis for expediting the anti-suit claim, in other words, the claim for final relief, was, in a sense, the precarious asset position. That my client, the bank, has assets that are executable in Russia with a pending Russian court claim in breach of the arbitration agreement, which looked, because of the public policy around sanctions, as though the Russian court was going to and be compelled to say no defence to payment under the bonds, enters judgment, which has happened since, and therefore execute against the asset. So the asset position has been prevalent throughout in that sense and justified expedition. At the same time and in parallel, you have the injunction defendant RCA challenging jurisdiction, both under Gateway and Forum. And what happens, not just in this particular anti-suit, but in others, certainly in my own experiences, that gets rolled up together. So you end up having a final hearing, an expedited final hearing for the commercial judge that also includes jurisdiction. You'll appreciate, obviously, there's an overlap between some of those issues. The proper forum inquiry did overlap to some extent with the Section 37 inquiry.
But there was no oral evidence, was there?
No, not at all. There's a final hearing, but on the papers.
Do we have the claim form?
I don't know if it's...
Well, the answer is we don't have the claim form.
No, we didn't know if
Could we have the claim form?
Would you, if that a request, then yes,
Yes,
we can
please.
obviously get to that, yes.
Well, it would help us understand the shape of the litigation.
Absolutely. So Sir Nigel...
It's a Part 8 claim form.
Yes.
And what was before Sir Nigel? Was that the trial of the Part 8 claim?
It was, on our part, and the jurisdiction challenge on the part of RCA, which prevailed, which meant Sir Nigel didn't need to and didn't say anything more about the availability of final relief if he'd been wrong about jurisdiction. He just decided jurisdiction. And then just to complete the procedural picture...
Well, sorry. How, if he just decided the application to set aside on jurisdictional grounds, to set aside the interim injunction, how was it that the Court of Appeal made a final order and not an interlocutory order.
Well, I was coming to that, which within the powers that it possesses, having allowed a jurisdictional appeal and asserted jurisdiction, it then went to the next stage of saying we have the power to grant the final injunction. There was a debate at that point.
Was that all it? I mean, it just did it. Boom.
That's the summary of what occurred about a year ago. Yes.
So it determined the Part 8 claim.
It did. And the reason for that was there was very little left. That goes back to my overlap point earlier. A lot of the points that were used and spent, as it were, a lot of that ammunition spent on proper forum fed into what could only ever be the debate on Section 37.
Is that contained in Lord Justice Mayall's judgment?
Yes, it is. And
Would you show us the passage at your leisure?
Yes. Would my lord like to see it now?
Yes, please.
Yes.
I'm sorry, I hadn't grasped that, and I should have done.
So the judgment of the Court of Appeal is tab 10, starts at page 50.
50.
Yes.
Page 50.
Yes, 50. I say it like that in case it sounds like 15 on numbers like that.
No.
And so you will have seen from the flow of that judgment, it deals first with the gateway point, the anchor point on proper law, then appropriate forum, which starts at paragraph 71 on page 67. And then you get the heading right at the bottom of page 69, should a final injunction be granted. So these are the reasons given in paragraphs 79 to 85 for the grant of final relief. But I should just add that is a decision that was communicated by the Court of Appeal to the parties after a very short break at around about 4 o'clock on the day of the appeal.
Sorry, but 4 o'clock, the court said the broke and then came back and said what?
First of all, we don't need to hear from you, Mr. Houseman, on the appeal, it being my jurisdiction appeal, in other words, appeal allowed on jurisdiction. And we, the Court of Appeal, are going to grant you the final order in the terms sought.
Final order.
Final order.
And
yes.
you'd asked for it.
Which we had. And just to finish something I'd started saying a moment ago, there was a debate between the parties. If I gesture towards Mr. Sebastian, that's a wrong gesture. He was not my opponent today. It's RCA. The debate was, RCA said, if the bank prevails on its jurisdictional appeal, the matter should be remitted to the commercial court for, I think they were saying something like a one-day trial in X months' time, which we regarded as stalling, rubbing up against the concern around executable assets.
RSA was saying that.
RCA said that.
RCA, I'm sorry, I keep on calling it.
We said that was bluffing and it wouldn't need that because there was just no answer to the injunction. There was no strong reason why the court should not grant a final anti-suit injunction in mandatory terms where you have a slam-dunk breach. You can't declare a breach of an arbitration clause when someone just brings the substantive claim in a court. So you've got the breach, then the only inquiry is strong reasons. The only real argument advanced by RCA was the sanctions argument, which amounted to saying we will do better in a Russian court than we will in a London-seated arbitration, sorry, a Paris-seated arbitration. To which the answer is, but you agreed to Paris-seated arbitration for this claim. So there were no strong reasons. You see that set out in more eloquent terms in Lord Justice Mayall's judgment in that section that I showed you.
With his conclusion at 85, yes.
Yes, absolutely.
Paragraph 80 is where he sets out the trial of the claim point.
Yes. So that's how we get to a final injunction in the Court of Appeal. Then RCA seek and obtain limited permission to appeal to the Supreme Court and from the Supreme Court, where this element is outside the appeal. So the Supreme Court said you can appeal on jurisdiction only, but not on the next question of grant of final relief. And so what you then find is the Supreme Court order, which is before this court, simply deals with the fate of the appeal, rather than afresh giving an injunction, which is why obviously the Russian court has made the order requiring the bank to get rid of, if I can put it like that, this court's order, because this court...
Well, I thought that was because, but obviously I was wrong, I thought it was because the UK Supreme Court had simply dismissed the appeal from the Court of Appeal's order, and the primary order granting an injunction was made by the Court of Appeal.
Yes.
And both are true, really.
Yes.
But the second point is, on one analysis, you really ought to have been applying to the commercial court to discharge because you're making an original application, but we have talked about that and thought that it would be probably overkill for us to say you go back to the commercial court, particularly bearing in mind that there are other applications that stand behind yours.
They stand behind ours and they stay at the first level, at first instance.
And there, at the moment, has any one of them has been granted? Has it?
Deutsche Bank was a case where the only order granted was interim relief. The only order sought and granted was interim relief. And that action has been discontinued, and the interim relief falls away with it. But of course, that's interim, not final, so it doesn't operate as any form of precedent for what we're doing today.
Could we be given the details of that, please? I say that because it seems to me that one of the arguments that will have to be debated is, for the sake of argument, why should the procedure that was adopted in this case, which prevents you entering a notice of discontinuance and thereby the anti-suit order falling away, be different from the Deutsche Bank situation which you've just described, where you don't have to ask the court, because at the stage of the action that had reached, you can enter a notice of discontinuance without permission, I assume.
I'm not quite sure on that very last point. It may well be the court still has some form of
right, but that's why
judicial function on discontinuance.
That's why I'd quite like just to know if you, and I mean, you may not know, but if you, whatever's in the public domain, I'd like to know.
Well, Mr. Claypool in his witness statement in tab 3 has covered it to some extent, but if there's more detail, we will
well, if there's any documents that we can be shown, it would be great to see. For example, the order that was made in the Deutsche Bank case, and the order, which must be public, terminating the proceedings.
Yes, and one of the submissions I'm going to make in due course is that what we seek from this court, and I'm glad we've established that this is the court to come to, is akin to discontinuance in the sense that even though it's post-litigation, in the sense that what you have here is a claimant who is the beneficiary of the relevant court order, asking the court to revoke or indeed vary it. I'm going to look at the draft order in a moment. And that, in some ways, then cuts into the integrity point, the integrity of the court process point raised by Mr. Sebastian, quite fairly raised by Mr. Sebastian, but also, as I see it, segues into the 2 points raised by the court, which comes down to the point which is my client is making this application. It's doing it as a matter of choice, albeit compromised choice. This is important.
What do you call it? Compromise.
Compromised choice. It's not doing it as an act of free will, but it is an act of choice. Because it could just say, take my $250 million, couldn't it? Banks, generally speaking, are supremely rational when they come to make decisions like this. And my client has made a decision that it would like to comply with the Russian court order rather than run the risk of losing the $250 million. That's a decision for it to make, that it has made rationally, I think this court has to assume. And therefore, it makes this application. It makes it in good faith. Yes. And it makes it to seek the removal or revocation or variation of a court order of which it is the beneficiary. And if it had done that before that court order existed, you'd be in discontinuance land, if I can put it like that. But we're not. So we run up against the policy of finality in litigation. So we're going to have a discussion about what that policy means, why it's there, and is it compromised in this situation. We will come to that. But the key point on volition and on integrity stroke assisting the contemnor is you are not enforcing or giving legal effect to a Russian court order that you don't like or don't approve of, or that you think grates with international comity. That is key. You're not enforcing, recognising or giving legal effect to the Russian court order, nor are you assisting a contemnor. You are being asked by an innocent party who is the beneficiary of a prior court order to revoke or vary the terms of that order, because it has come before the court having made a choice to seek that revocation variation.
Well, the only sense in which we could be assisting a contemnor is if we accepted Mr. Sondal's application, or we accepted RSA's application, and you say we're not.
No, but this application is not made by or on behalf of RCA. It's made with the support of RCA.
Sorry, I call it RSA all the time. I've got in my head for some reason that it's RSA, and I'm looking at my notes now. I've written down RSA and RCA interchangeably ever since this case started. I will try and remember that it's RCA. Yeah.
I corrected a judgment of my own on the National Archive where I got the claimant and the defendant the wrong way around.
Right, okay. Yeah, okay, well, RCA anyway. Yeah. So,
but yeah, I know what my lord means. Sorry, maybe Lord Justice Phillips has a question.
Perhaps just to clarify, in relation to discontinuance, the general rule that a claimant may discontinue at any time in 38.2.1 is caveated with, however, the claimant must obtain the permission of the court if they wish to discontinue all the part of a claim in relation to which, one, the court has granted an interim injunction. So the court would in any event have to give permission for discontinuance.
We will come back to this, but this for me goes to the integrity of the court process point, or whether the court is being seen to assist a contemnor, which feels to me, or indeed being seen to give legal effect to a foreign court order, which it is entitled to regard as contrary to international comity. Those are the integrity points as I understand them. Is it the right thing to do and be seen to do? And the answer to all of that is they are not engaged, because that's not what you are doing. It's not what you will be seen to be doing. What you are doing is, if you grant this application, is acceding to an application made by the beneficiary of the court order that has made a choice, albeit a compromised choice, under legal compulsion, to seek this relief from this court. It's done that, and this is crucial too, in circumstances where the source of the prejudice that flows from that court order that it seeks to revoke or vary was both unforeseen at the time the relevant order was made, so 29 January of last year, and has arisen other than through its own responsibility, because you would appreciate my client in Russia fought the anti-suit and resisted the anti-suit and said you can't do this and that the English court won't do this and various things. So the situation that you're presented with here is that, and this is why this case, if you want to rationalise why this case is exceptional and why it can come under CPR 3.17, it comes down to this. In circumstances where the beneficiary of a court order is now prejudiced by its own court order, in other words, that court order has become the source of prejudice to that party, in circumstances which are both unforeseen and not of its own responsibility, there must be a facility for that party to come back to court and say, please revoke or vary that because that's causing me pain. Now, whether that's part of the court's residual inherent jurisdiction, as enshrined in CPR 3.17, or only found in 3.17, doesn't matter, that's an arid debate. But the notion a party can't come back to court and ask to be relieved from the consequences of a court order of which it was the beneficiary in those sorts of circumstances would feel harsh, and I will say that.
If you'd agreed in the circumstances of this case, Russian jurisdiction between you, in a case of a tussle as to jurisdiction, presumably the court here would have automatically agreed to the discharge of the order if you came back and said, we've settled the jurisdictional questions, we all want to go and litigate. I'm assuming there's no orders made already in Russia, but you'd agree that both sides were campaigning. I mean, you might be campaigning for Italian jurisdiction. UniCredit being an Italian bank, and they were campaigning for Russian jurisdiction. You hadn't had any decisions by those courts, and you come back having applied for an injunction and got an injunction here or anywhere, and say we've agreed Russian jurisdiction. You say, well, it's obvious you'd agree to discharge the order.
That being an interim order.
Well,
Or
the query, whether it makes any difference in that situation.
yes, no, I see that. I've got slightly ahead of myself, but so it may be an idea. I don't think I even finished telling you my 5 headings.
You didn't start.
Let alone starting on the subheadings within heading 1. Can I do that? So outline, which we've now foreshadowed. It's often the way when I make submissions, is you get to the point pretty quick. Section 2 is going to be background, but again brief, because I ascertain that this court knows how we got here. That will be brief. Then law, because I don't think I'm going to say anything between us, but obviously this isn't an adversarial situation. But my submission on the law, just so you have it, is it has been recognised at Court of Appeal level, including most recently in Vodafone that my lady was in, that power in the CPR is available in relation to final orders. Now, the extent to which that is the case, the circumstances in which that can be invoked are not clear, and that's, in a sense, what we're going to test today. So that's law. I was then going to say separately, heading 4, some points about public policy. The 2 public policies in play being the policy of finality in litigation, which is the biggie, and the policy of protecting the integrity of this court's process, which I see as very much a secondary, and you've already got some of my points on that. And then finally, in a sense, bringing that together under the heading of analysis. By that stage, I suspect you know exactly what I'm going to say, and that will be very brief. So, in terms of outline, there are 5 or 6 points here. The first point we say is fundamental, which is this application does not seek to reopen the relevant Court of Appeal order, the so-called 29 January order. This application, as Lord Justice Mayle said when he gave his direction, I think last week on the 24th of January, paragraph 4, nothing has occurred since these judgments were given to suggest that the injunction was wrongly granted. Paragraph 4, Lord Justice Mayle's order, that's tab 43, page 584, and of course that is axiomatic in this case. That is just the case. So this is not a case where a party is coming back to court to reopen a prior decision on the basis of some aspect of the quality of that decision, either the process leading to it or the intrinsic quality of the decision itself. That's not happening here.
Now, you're not arguing with
No.
Lord Legate's lengthy analysis.
No. And in some ways that is not surprising because we are the beneficiary of the decision in question. So you might say that's simply a product of the fact that it's our order, as it were. We got what we wanted, we just no longer want it, if I can put it in those very broad terms. But that's important because the CPR 52.30 point, because a thread in the case law, obviously, is if you are seeking to reopen a prior order, then you have to go through CPR, what is now CPR 52.30. You can't circumvent that. And if you happen to go under the parallel jurisdiction of 3.17, which you can, as a matter of bare jurisdiction, you can't use that in a way inconsistent with 52.30. And we'll look at Vodafone in due course, and Vodafone reconciled 2 prior Court of Appeal decisions, which seem to say slightly different things on that front. So you can't get around the 52.30 mechanism and test, which is a high test.
But you say this has nothing to do with 52.30.
Absolutely, yes. And for the simple reason that we're not seeking to reopen. Now, the concept of reopen is the word used in 52.30, but it's important to bear that in mind here, that there is no reopening. So nobody is asking for a different order to be made with different reasons. We are asking for the order to be revoked, or alternatively to be varied to excise the anti-suit only. It would keep the declaratory relief, it would keep the determination of the jurisdictional appeal, it would remove the anti-suit relief, and we'll look at the draft order. So that is crucial. That's the first point.
It's not a reopening, you just don't want it anymore.
Yes, yeah. But in plain language, whatever want ever means in any context, yes. And that comes back to the choice point. My client has chosen rationally to no longer want this order because because it deems that to be in its best interest as a result of what the Russian court has compelled it to do. So point 2, which flows, well, it doesn't flow from that, but it picks up what I've already said, is it's important to keep in mind that this is not an application by or on behalf of RCA. That is important. The fact that it arises from legal compulsion under a Russian court order procured at the application or behest of RCA is extraneous. It gives, that's the context.
Well, yeah. It's created by RCA.
Yes. But there's a legal compulsion that has come into being, a legal compulsion operating on my client and its decision making, which has...
Whenever you have a jurisdiction battle, if this court grants an anti-suit injunction, as it did in this case, it expects the respondent to comply with that in the foreign jurisdiction by discontinuing the proceedings. Just like it expected in this case, RusChem to comply by discontinuing the Russian proceedings. Is that coercion? Yes, it's a coercive order.
Yes.
And in jurisdiction battles, often the court in the other jurisdiction will injunct the party invoking the English jurisdiction to discontinue. And then you can have an anti-anti-suit and an anti-anti-anti-suit, and it goes on and on.
It does.
Now, does that mean that the party who, in a sense, loses the jurisdiction battle can't actually comply with the order that they are obliged to comply with? For fear of, do we now say that that we expect a Russian party to comply with our order, but we say that you can't comply with the Russian order when the jurisdiction battle has been lost?
Well, there is something in that. And it feeds into the broader point about the integrity of the process, because I would say acceding to this application is not allowing the integrity of this court process to be compromised or interfered with or intermeddled with by another court, because of the straightforward anti-suit analogy, because that's what we do when we grant anti-suits, and it's trite in contractual anti-suits that historical concern around international comity has fallen away, because what international comity does in this situation is it enforces bargains. On the reciprocal basis, other jurisdictions enforce bargains. Pacta sunt servanda, as Lord Legate says here.
Well, one thing is recognised is it said one of the reasons why the English court can grant anti-suits and that they're consistent with comity or comity, how you pronounce it, is particularly justified in relation to other jurisdictions where we know that they grant anti-suits.
Yes.
Because we say, well, it's fine to grant an anti-suit because that jurisdiction understands how it works. And so in that situation, if the converse happens and the other jurisdiction grants the anti-suit, do we turn around and say, well, actually, giving effect to that anti-suit is not permissible?
No, we don't.
We don't.
Absolutely, and that's because the fundamental position is, of course, these are all injunctions which operate in personam on the relevant defendant, the relevant litigant. And that's what we say. I mean, it doesn't start with Lord Hobhouse and Turner and Grovet, but it's a theme that's come right the way through. And that's why international comity is not the concern on the contractual front, which this case obviously is, and a fortiori on the arbitration front, because of that whole international policy of arbitration bargains in particular. And I was going to come to this because this is there is no interference point. And if you tested that in the pre-final order situation, so you take finality policy away, we'll come back to that. In the pre-final order situation of normal litigation here, anti-suited by a foreign court, if I can put it like that, this court would, if the relevant claimant here was forced to discontinue its claim here as a result of a coercive order from the foreign court, the foreign anti-suit, this court would just say, fine. It would exercise a judicial evaluation so far as necessary under CPR 38 that my lord has pointed out.
I mean, and I get all that.
Fine.
And I don't think any of that is particularly controversial. I think what is potentially controversial is that the material change of circumstance that I focus on is not the change of circumstance that the Russian law has changed, which I believe it has, the Russian jurisprudence has changed, which it may have done as well, that different orders that were unexpected have been made by the Russian court. The change of circumstance that raises my judicial eyebrow is that the party that had previously submitted to the jurisdiction of the English court and said expressly it would comply with the orders of the English court did an about-face when it got the order it didn't like.
It did. Whether it's submitted is perhaps a
okay,
characterisation.
Yes,
that's... I know what my lord means by that.
Yeah.
But that is no more than saying RCA, through its post-order behaviour, may have put itself on the wrong side of the English contempt regime, and therefore one can, functionally speaking, describe it as a contempt law. And then we're back to the whole, is this really about not assisting a contempt law? To which you know my answer, you're not, because this is not an application made by it or on behalf of it. This is an application made by my client under a legal compulsion that has arisen out of those circumstances. In a sense, the buck stops with the legal. This court is not required to evaluate the rights and wrongs of the legal compulsion which operates on my client's decision making. It is the current world state of affairs that operates on my client, and as a result of that, court means that this court order, as in the 29th of January court order, is the focus of this application, now causes my client prejudice in a very real way.
In a jurisdiction battle of this nature, what happens is either one or both ends up in contempt, or one accedes to the order and discontinues proceedings. And that's inevitably going to happen in the well-recognised scenario of anti-suit and anti-suit injunctions.
There's a wrinkle to that, which is you could have the injunction defendant not in contempt. So let's say it complies with the final mandatory anti-suit by going to the local court and saying, please discontinue my claim.
Yes.
And in the case probably only of the Russian courts, I have to say, because this is now anecdotally what we see, the Russian courts ignoring it. So you can have the Russian court choosing for its own policy reasons not to accede to a motion to dismiss or a motion to discontinue, notwithstanding the fact that the injunction defendant has done that which the English court compelled it to do.
It must have happened before that English parties subject to a foreign anti-suit injunction must have come to court and asked for the proceedings to be dismissed or discontinued.
Yeah, I'm sure it has, yeah.
So it just doesn't seem to have, this issue never seems to have
hit the books.
Well, but the reason for that surely is it's of no concern to the English court as to exercise its permissive power to allow the discontinuance, to inquire anything further back from the fact that the application has been made. And then you're down to party autonomy, used in a different sense than in the arbitral law.
Yes.
You're down to the fact that a litigant, in this case a claimant, has said, I no longer want to pursue my claim. Why would the English court inquire as to the circumstances beyond that? It will lay those reasons out. I am under compulsion from a foreign court. I'm risking foreign contempt. But they are simply the context and the impetus. But it's no part of the court's job to look into or evaluate that. It just is what it is. And therefore acceding to that discontinuance request is not allowing a foreign court to interfere with the English court process in any sense at all. And let's take that situation and put it into our post-final order case here, nor is it here. The only thing you rub up against when you lift it over and put it into the post-final order case is the policy of finality of litigation, which we're going to come on to. The short answer to which is where the claimant no longer wants, or rather when the beneficiary no longer wants the order, what's the problem with finality? But there's a more nuanced answer to that.
For my part, I think it's very different to say there is a policy of finality of orders that relate to anti-suit injunctions and the policy of finality that might apply to other kinds of injunctions.
I wasn't saying that at all. I was saying if you're looking at a situation where a party either seeks to discontinue, asks the court to discontinue because it's under a foreign legal compulsion, on the one hand, so pre-final order, and then lift it over into the situation post, the only difference in terms of perception of interference with this court's process is that there's no difference. There's no difference. The only difference is the policy of finality in litigation, and then you just have to undertake the balancing exercise that the Supreme Court says in the AIC case. Is there a compelling case for allowing this to happen, notwithstanding that policy? And we'll come on to that discussion in due course. But in a sense, this line of questioning has picked up more of my overall outline point. So the second point was, this is not an application by or on behalf of, in a sense underlined or on behalf of, nor is it an application by RCA by proxy. It just isn't. This is an application by my client having made the decision that it's in its best interest because the existing court order causes it pain. And that then flows into the volition point, which is, it is an exercise of volition in the sense that you have a bank operating rationally and in good faith that's decided it is in its net best interest or net better interest to make this application and be seen to comply and indeed hopefully comply with the Russian anti-suit rather than to not do so because of that €250 million execution risk. And interestingly, if we still have the Court of Appeal judgment open in this case, in the UniCredit case, if the court can go back to page 69, where the court was getting towards the end, Lord Justice Mayles is getting towards the end of the forum analysis, paragraph 77, where the Lord Justice was dealing with the viability of going to Paris arbitration to get an anti-suit order, because that was one of the strands of the debate on forum. In the middle of that paragraph, you see Lord Justice Mayles dealing with a point about a potential Russian anti-arbitration injunction. And then you see the sentence, as UniCredit has assets in Russia, it would then have no choice but to comply. The point being, if we were packed off to Paris arbitration to get the anti-suit, the Paris arbitration would be torpedoed by a Russian anti-arbitration injunction, and UniCredit would find itself in an analogous position to which it now finds itself, which is on the wrong end of a coercive Russian order, with the pinch on having executable assets in that jurisdiction. Now, the phrase used there is no choice but to, and that's a phrase used in our skeleton argument, paragraphs 10 and 35, we say had no real choice, but there is a choice. You might call it a Hobson's choice or a Morton's fork or a devil's dilemma, I don't know. It's a pretty awful choice, but it is a choice, and I think that's fundamental when we're looking at the volition theme and the perceived interference with this court's process theme. It's like none of that is actually going on. It's just an application made by someone who no longer wants the court order, if I can put it in my lady's language. So that is that. I will try and cut through these because we've covered some of them. We then get to, well, what is CPR 3.17 there for? And we'll look at some law. What I'm going to submit is, and what I do submit is, that is there as a backstop jurisdiction to deal with cases of injustice. If it turns out that a court order later becomes the source of injustice or prejudice to the party who wanted it and got it, then why can't that party come back to the relevant court and ask for it to be removed? And as long as it's only becomes so for reasons which were unforeseen at the time, which is the case here, and as long as it isn't complicit in and isn't responsible for that changed state of affairs, which the bank is in here, then it's coming to this court with clean hands, if I can use that phrase. It's the innocent victim of someone else's bad behaviour. And this court shouldn't allow its view of the quality of behaviour of the other party to blind it to the injustice caused to the party that's coming before it innocently and in good faith and asking for a prior order to be revoked because it no longer wants it. Just look at the bank. That's the submission. Now, can we then go to some of the materials, but quickly? If we can look quickly at the draft order that we seek from this court in tab 2. And again, cutting to what matters over on page 10, we seek primarily revocation of the 29 January order, which we're going to look at next, or else variation, because obviously the rule we're coming under says revoke or vary. And then to give that context, if you can go please to tab 7, page 34, this is the Court of Appeal's order. And if we go to page 35, it had a series of definitions then a series of declarations, 2 to 4.
Why would we keep in place any part of this order if we decided you were right in your arguments?
Under the primary application to revoke, the whole order is revoked. So it goes. Now, let's test that logically. That means that the appeal on jurisdiction had no outcome, because the order which dealt with the fate of that jurisdictional appeal has been revoked, so it's gone.
Right. So you would say we could logically keep in place the declarations on jurisdiction.
Yes, you could.
And could and should.
In the sense that's for the court, I would say. And now that might...
You're just as happy with that?
In terms of practical outcome, yes. What I can see is that when we are weighing up the risk, the practical risk to my client of getting no order from this court against the policy of finality of litigation, and that weighing, the outcome of that weighing exercise might more naturally direct this court towards a variation that keeps some of it. Because this court might feel troubled by the idea of erasing this order forever, because then get in our time machines and go back to January of last year, you had an appeal that had no outcome, and that might feel unsatisfactory. So,
well, and also Lord Leggatt might have something to say when he'd spent all those days writing that that exposition on the subject, which would then turn out to have been something that didn't have in history's face an order.
well, I wondered about that, but it's going to involve jumping slightly ahead to the policy of finality and litigation.
You're not applying to set aside. You're not applying to set aside the Supreme Court's order.
No, we're not. No.
So
But the Supreme Court didn't make an order except the appeal is dismissed.
Well, we'll look at that in a moment, because it said slightly more than that, but just so you have the full picture.
Yeah, but it said the declarations stand.
It does, yes. They remain in force, yes. So it had an operative element. It didn't just say appeal.
Well,
dismissed, yeah.
well, yes, but
But if there's nothing left,
it's illogical for us to say the declarations to do away with our order, leaving in place the Supreme Court's order saying the declarations stand. So the logic of all you're saying is that we should actually vary, not revoke, because that doesn't tinker with the Supreme Court's order, because otherwise you might have to go to the Supreme Court and say, what do you think about this?
I think it's fair to say that I had developed a discomfort, a vicarious discomfort, as it were, in the last few days, as to if I was being asked to make this order in your position, what would I think does the least violence to the policy of finality and litigation? Because I struggled slightly conceptually with the idea that there would have been an appeal with no outcome if you revoke the whole order. I hadn't seen it as the next level up, that the procedural basis for what the Supreme Court did was also taken away in the same breath. So the solution to that's variation. But of course, what Lord Leggatt had to say about all of these important issues remains part of our juristic heritage anyway, come what may.
Yes, it does, but this court doesn't like stepping on the toes of the Supreme Court more than is necessary.
No, or maybe in this case chopping its legs away. I don't know. It might be a metaphor. But I see all of that. And the
Supreme Court ordered that the injunctive relief remains in force. But there's no problem with us discontinuing the injunctive, discharging the injunctive relief, notwithstanding the Supreme Court has so ordered.
Well, I would say not, because the paragraph 3, I mean, if you want to jump ahead to that, it sounds like you have it in mind. It's tab 8, page 38. So paragraph 1, appeal dismissed. Paragraph 2, the stay, the mandatory, because that had been suspended pending the appeal, is lifted immediately. And then paragraph 3 is the one that we're talking about. All of the declarations and injunctive relief remain in force. But of course, if the Court of Appeal's order is revoked, so there is no injunctive relief, then there's nothing to remain in force.
But it says therefore.
Yes.
So it's really just declaring the effect of having dismissed the appeal, I think.
Yes. And I would say, I can understand this concern. It's not one I lent my own brain to. But
I mean, I think this is how many angels can stand on the point of a needle in many respects. I think we do have to come, because we don't have unlimited time.
No.
We've had an interesting and wide-ranging debate, and you can see where, anyway, my concern is. My concern is that in acceding to your application, we are either are doing something unlawful, that we might be doing something unlawful, that we are condoning, as you put it, the activity of a contemnor, or in effect doing something that could be regarded as contrary to the integrity of the judicial process here. And personally, I'm not sure that is about the distinction between final and interlocutory relief. Speaking only for myself, it seems to me that there is obviously power, jurisdictional power, to do away with this order at the behest of the parties. Mm. The question is whether we should. Mm. And you probably gathered we've done a bit of thinking about this before you turned up this morning. And we completely see, or I completely see, the compulsion that has brought you here, and all your points about this is me talking, and we're a bank, and we've made we've made a sensible decision, even if it's under pressure, and the pressure applies in all of these anti-suit situations, and that's what anti-suit is about. So we sort of get all that. My only concern is that in acceding to this application, in the events which have happened, we would be condoning, we would be acceding to activity which is properly so called under English guides unlawful, contrary to the rule of law, and in conflict with the principles upon which we operate. Mm. Now, I express it in that very general way because it may be a question that is simply, the answer is, well, obviously not, for all the reasons you've just given. But that's the residual concern that I certainly have.
I understand that, yes. But it may be I don't have an answer to that beyond what I've given, which is simply you don't look further than the applicant before you, and you don't look further than its behaviour. And as long as it is innocent in the set of circumstances which have brought around the legal compulsion, and as long as that legal compulsion, that new world state of affairs, was unforeseen at the time of the order it now no longer wants, that's the extent of your inquiry, and you're not doing more than that.
But is the answer you're saying that the English court is not an island? So in any situation in which you can understand that pressure is applied externally in a different jurisdiction, that is the nature of international commercial activity.
You could see it that way, yes. And then within that, the English court is not required to form any evaluative view on the rights and wrongs of the foreign compulsion at all.
Well, the English court, to be clear about this, the English court would never form any view, positive or negative, of the activity of a foreign court. That would be contrary to the principles of comity. Mm. And I don't think that would be helpful at all. It might form a adverse view of the activity of a foreign party before the court.
Yes.
And then the question is whether that leads to, or could lead, and in what circumstances it could lead to the court refusing an application. So if we were to regard this application as being made not by you, but by the, the person RCA who has caused you to be in the position you are, then we would be acceding to an application by somebody who has held our process in contempt. Now, that would be something we would be worried about, wouldn't we?
You would if it was properly characterised as an application by or on behalf of.
Which is why you're so keen to say it's not.
Well, I'm keen to put things to you with integrity, analytical integrity, and I do not think it can be said that this application is made by or on behalf of RCA.
Because you're a big bank and you know where your interests lie, and your interests lie in keeping your turnover $250 million, whatever.
Yes, things haven't turned out as it was hoped at the time this order was sought.
Quite a simple case then.
Well, RCA isn't practically amenable to the English contempt regime, so it's not going to be every case, is it?
No, but if it were, what would be the position?
Well, we may not be here now, who knows? And it's a debate we had in the Supreme Court. More than once, Lord Legate asked me, well, albeit straying over the line into final relief, I have to say, how do we know this is going to be obeyed with? Is this going to work? And the phrase brutum fulmen came up in both of those exchanges, because unless it's the case that the injunction is shown to be futile, it is granted. And so it was. It just turned out that the contempt discipline didn't operate on RCA, and it did change its tune, if I can put it like that. But it is key. I can't point to a case that provides the answer on this point. Obviously, this is a matter of principle and impression to some extent. But I would say simply that if you are invoking a jurisdiction to come back to avoid prejudice to yourself, by the bank, that's all you look at. You look to see whether this order in this changed world state of affairs causes prejudice to the beneficiary of the order. You don't look to see whether someone else who's behaved badly in the eyes of English law benefits as well or in parallel, or brought about the state of affairs themselves. That's extraneous or collateral. It's literally about helping or alleviating injustice. And you look no further than the party who says it's going to suffer injustice. Now, on that, I was going to turn to the risk, because Mr. Sebastian took a point on what he calls, in a sense, the threshold factual issue. Is there a risk here?
Just before you leave, just to perhaps square the circle or whatever, if RCA did have assets here, and you were now here, instead of applying for this relief, you were applying to commit RCA for contempt. And RCA, to avoid that, went to the Russian court and discontinued. The obverse would be exactly the same. It could be said that RCA is only making that application to discontinue in Russia because UniCredit has, in breach of the Russian injunction, made an application here. And so if we are saying that what you are doing is coercion, well, that's exactly what the English court expects to happen with it when it makes or contemplates making a contempt order in this situation.
Yeah.
It's obviously, it goes to the territory of a jurisdiction battle, and at the end of the day, the party who loses the battle is going to go to the jurisdiction and say, we've lost the battle, we need to discontinue. And had RCA got assets in this jurisdiction, then it may be they would have lost the battle and gone to the Russian court and said, please can we discontinue? And that would have been because you were breaching the Russian order. So I'm not sure how much one gets out of this concept of who is about the conduct of the winning party, as it were.
I'll give that some thought if I can. But I had thought the example my lord was positing was one where there was a pending committal application and there was a Russian order forcing that to be withdrawn, because I could see how there'd be a different policy at play there. The English court protecting obedience with its orders, but I don't think that's the example. My lord was positing the obverse example. Maybe we'll come back to that and I'll give that some thought. On the risk, two things are said on the risk by Mr. Sebastian by way of observation. First of all, the risk isn't there factually.
Sorry, the risk?
The risk isn't there factually. In other words, it's enough, on the face of things, it's enough if we make this application. And if I stand up today for however long and conscientiously present the application, therefore my client has done everything it can do under the Russian order and it's fine. So he says that risk doesn't exist factually, the risk of not getting of being in Russian contempt if we don't get this application granted. Secondly, he says, well, even if there's a real risk, that's not enough to displace the policy of finality of litigation. So those are 2 points. But at this stage, I was just going to deal with the factual position. The short point there is the position has shifted. It is the case, as you will have seen, that the Russian anti-suit, and we can have a quick look at that. That's tab 13. And the operative part in the order itself is on page 117. And it's obviously paragraph 3. So this is what we would call a mandatory injunction, which compels, or as it says, obliges the bank within 2 weeks to take all measures within its control aimed at cancelling the effect of the order of the court. Now, the context for that was the application itself. I'm showing you this in a sense out of fairness so you can see the full picture. It's right that you do. That's tab 30, page 223. The original application. And if you go, please, to page 245 in the what's effectively a prayer, where it says, I plead. Again, paragraph 3 is in different language. It was harsher. There was nothing about all steps within control. It looks on its face of it like it's an absolute obligation to withdraw claims and framed in the sense as discontinuance. So RCA took some form of advice, we infer, and amended that application, which you see in tab 32, page 253. It's a document headed in translation, which these all are, written explanations of LLC RusChemAlliance regarding the petition. So we're now on to the 19th of November, and this is amending the original application, which is 6 September last year. And what you see, if I can just divert the court's attention to paragraphs 16 to 20, is a recognition that this court would have discretion, and therefore the Russian court shouldn't make the mandatory compulsive order in absolute terms. It should make it in terms that recognise that this court has discretion.
So 18 is the sort of language from which the court moulded its order.
Yes. And this was done also with expert, I'll show you very briefly, there was expert evidence from rival English barristers as to this court's CPR 3.17 power as well. But for present purposes, I'm showing you the evolution of the application. So 16 to 20, the court should have in mind. And then that manifests itself in the prayer, as I'm calling it, over on page 258. So this is the amended paragraph 3, I plead, and then it says in 1, to clarify paragraph 3 of the petition, and then you have the new wording. And that's the wording which you then see granted by the Russian court. I think it gave its ruling on the 23rd of December with formal reasons that you've seen on the 28th of December, and that's that 14-day period. And the background...
The wording's a little bit different, isn't it?
Well, that could be a translation issue, but yeah, the order as made is take all measures within its control, including applying to cancel and others. And this document says all measures dependent on aimed at annulling. I think in substance it's the same, it could be a translation. But either way, you can see why there was that softening, as it were.
Can I just ask you, that on the face of it doesn't appear to, that seems to suggest you've got to cancel the whole order, and not just the injunctive part.
Well, yes. Yes, I mean the order's been made. Just by way of context, the application that has been made with the draft order with its primary and alternative positions is something that RCA's legal representatives have said is acceptable.
What?
Which?
What's acceptable?
The form of the order of the application that has been made with the draft order I've shown you.
Including the variation.
Primary revocation, alternative variation. And they have said in terms that making that application implicitly, conscientiously presenting it today, they themselves will regard as compliance. Now there's that separate point whether the Russian court will my lord's observation is not inapt there. And I was going to then show you the English law.
But it's a matter for us. I mean, it's not, preeminently, it would be inappropriate pressure to say for no good reason that the order should be cancelled in its entirety, rather than the operative part being cancelled. I mean, it would be the kind of interference that would be, it seems to me, singularly inappropriate, because we would if we left in place the declaration as to jurisdiction, which gives substance to the reasoning of the Court of Appeal and the Supreme Court, that's our business. It doesn't have any effect on anybody outside.
No, it may be.
It's our law.
Yeah.
And the reason we're leaving it, would be putatively leaving it in place, would be because there was a big legal argument about whether or not our law was this or that, and it was decided that it was that. And we would be saying there should be an order to reflect the decision that it was that. And it's got no effect on the parties.
That's another aspect of the debate we were having 20 minutes or so ago when we were looking at the order itself. Now, it may be that I will finish showing you the materials briefly on this point, on the risk point, the existence of the risk, and what the risk is, but it may well be that the representative from RCA can assist the court on the point raised by Lord Justice Phillips, which is, well, would RCA accept that the granting of the variation order would not put the bank on the wrong side of the Russian anti-suit, notwithstanding the strict language in translation of paragraph 3 of that anti-suit order? So that confirmation will obviously assist, because the worst case for my client in some ways is to get some form of win for today, or whenever the reason comes out, but find itself that it's actually in breach of the Russian order.
I mean, let's ask Mr. Sondor if he has anything immediately to say about that.
Very well, if it assists the court, yes. You would like to?
Well, I'm just asking. I mean, Mr. Sondor, do you have anything you can say about that now, or do you want to think about it?
Well, I was thinking of taking this point during my submission, but my instruction is that a partial variation of the order that directly concerns the rights of RCA would be acceptable for my client.
Right. Thank you.
But I would like to elaborate on that later.
Of course. But thanks. That's a helpful indication.
Now, rather than show the rival English law expert opinions that went before the Russian court, which I could, but I don't think you need to see, what I'm going to show you is the Russian law evidence you have on this application, the so-called KIAP letter, K-I-A-P, which is tab 14, page 119, because that, in a sense, takes in the points that you need. And if I can ask the court to look, or indeed read, paragraphs 5 through to 8, so the conclusion is in 8, based on 5 to 7.
I'm very sorry, could you give me the reference again?
Yes, of course. It's tab 14, and actually if you go to page 121.
And paragraphs 5 to 8.
Indeed, yes, my lord.
Yes.
So the analysis is, in a nutshell, because the Russian court had before it English law analysis through expert evidence, that CPR 3.1(7) was the available jurisdictional gateway, if you like, or head. under which to seek a revocation, you can take it as a matter of Russian law that the Russian law order as made that says what it says means my client, the bank, has to make an application under that head. So we would call that a factual matrix for construing a court order or something similar. The next piece in the jigsaw is over in the next tab, which is a letter the same day from LW, and it's paragraphs 3 and 4, and in the case of paragraph 3, that sought to give some form of comfort.
So which page is that?
So that's page 128 electronically.
3 and 4.
Yes, and paragraph 3 is the comfort. But as I said a short while ago, or maybe a not so short while ago, it's a comfort given as a matter of private accord, as it were. It doesn't necessarily mean the Russian court would see it that way, but we've operated on the basis of that comfort so far, until that is to say, we got the further LW letter, which has been put in and I believe stands as submissions formally on behalf of RCA pursuant to the Master of the Rolls' direction. That's tab, I think, went in as 46, starting on page 591. And I think we can do this without reading too much of it. If the court goes to page 596 and reads that section, practicality of the final ASI order, with a focus on paragraph 26.
Yeah.
So quite what the risk is isn't always stated with consistency, because a reading, and I would say the natural reading of paragraph 26 of that subsequent LW letter is, if we don't get a result on this application, we may find ourselves, the bank that is to say, in breach of the Russian ASI, as we're calling it. And not just my client, but those other German banks you see there in the separate anti-suit litigation that's pending at first instance. And Mr. Sebastian, for his part, has picked up on that and said, well, where does that leave us? Well, it leaves us in a situation of some uncertainty. There is a risk. No one is disputing the fact that there are executable assets, some frozen up to a certain amount already in Russia, against which the restraint could be enforced, perhaps even in preference to the trial judgment. So the trial judgment is 463 million euros with interest accruing. The restraint is $250 million. There's no reason to suppose the Russian court wouldn't just enforce the restraint domestically. That there are different issues about seeking to export an restraint, and that was the subject matter of the recent Google case in the commercial court. But it could easily just enforce against those frozen assets and then look to enforce the judgment either abroad or against yet more assets. So no one's disputing that factual position in terms of the location of executable assets. The risk is defined within the parameters of the documents that I've shown you. Insofar as it's inconsistently stated, that is a concern for a rational decision maker like my client. And you have the language of the order itself, as pointed out by my lord. So that's why we are here. Separately from that, the second point Mr. Sebastian has raised is, well, is that enough as a real risk to counterbalance the finality of litigation policy? And if I may, we'll come on to that. But we will say a small risk of something big happening. It is not a small thing itself. Can I move then to the law? I wasn't going to spend an awful lot of time, so my third heading, that is to say, I wasn't going to spend an awful lot of time on CPR 52.30. You've got my primary submission that we're not seeking to reopen, and if we're not seeking to reopen, we're just not in that at all. But the court can take note of the fact that that is a jurisdiction which is now codified, as it were, within Part 52. It was formerly 52.17, I think, and it emanated out of the case of Taylor and Lawrence, the judge's apparent or otherwise bias in that case, now that you probably know the facts of.
This is not really a Taylor and Lawrence situation.
I'm sorry?
This is not a Taylor and Lawrence situation.
It's not, no. It's not,
Okay.
and for the reason I opened with, which is we're not seeking to reopen an order, we're just seeking to either remove it or cut it down. So we can move past that, but that obviously has implications through cases like Gregory and indeed what's commented on in Vodafone, which is even if there's a parallel jurisdiction as a matter of bare power to go under 3.17, insofar as you were using that to reopen a previous order on appeal, then you would have to satisfy the conditions of 52.30. In other words, you cannot circumvent. And what we will see when we look at the case law on the use of CPR 3.17 is a constant theme is there an alternative way of doing this or of avoiding the relevant injustice? And therefore in the appeal context, it's about, can you appeal out of time? That's the primary way of doing it. If you want to set aside a judgment for fraud, you can bring your fresh action to do that. And so in the case of Terry, the Court of Appeal says, well, you can't strike out an existing case for abuse of process because you can bring the fresh action to set aside for fraud. And if you can't strike it out for an abuse of process, nor can you use 3.17 to achieve that same result by a different mechanism. So a constant theme running all the way through this is there an alternative procedure within the CPR to achieve the result, i.e. avoid the injustice, which is sought? And I recognise that and I accept that. But I say there isn't here, for all the reasons you know and that we'll come on just to finish up on. And then another illustration of that, of course, is Vodafone itself, where because it wasn't unforeseen. So the facts of Vodafone, briefly speaking, are infringement proceedings under a patent happening in parallel with pending revocation proceedings in the EPO. The infringement proceedings succeed. There's a declaration of infringement, an inquiry as to damage.
Is it in the authorities bundle?
Well, we were going to look at it in due course, but I was just finishing an overview point, which is that if the supervening event is foreseen, then there are other ways of avoiding it within the CPR, primarily a stay or an adjournment or a case management issue. So again, this all fits the same theme. If we can start with Tibbles, which is Authorities Bundle 7. Or perhaps 9. So page 129 for the authorities.
One, 2, 9.
129, I hope.
I've got Dalla. 129.
I didn't catch the name of that one.
Dalla. Have you got the? I think I'm looking at the other thing.
It must be the wrong thing.
Yeah. Just give me a second. Can you? I was given an updated bundles. I may not have. Okay. What was your page again?
129.
Yep, got it.
So this is often regarded as the leading case on the use of CPR 3.17, but it's obviously about an interlocutory order. That is to say, the allocation of the claim to the fast track without any order being made about accrued costs, what should happen to accrued costs. And there was then an attempt to reopen that order and say, well, actually, we would like that order to be varied to then make allowance for the accrued costs, because obviously the costs have their fate once they're into the fast track. And it's well known for the summary of the principles from Lord Justice Riggs at paragraph 39. If the court can go to that, obviously decided in the context of an interlocutory order. But that's on page 140. And we see this summary then quoted by the Court of Appeal in Terry when we come to it.
Yeah.
And the strong takeaway from that summary, in particular in Roman 2, is that there shouldn't be an attempt to exhaustively define the circumstances in which this power can be used, albeit that they will be rare, and that's Romans 7. And the injunction, if I can put it like that, against exhaustive definitions isn't just in Roman 2, it's also there in Roman 3. And it's something picked up on in subsequent case law, as I say. That's all I wanted to show you from that, because that, again, is important in our case, because obviously there's no case like the present one, but it doesn't follow from that that the present one isn't one where the court should exercise its power. If I could ask you then, please, we're going to look at a series of 3 Court of Appeal cases now, touching on the question of the applicability of this rule to final orders. The first one of those is Rult in tab 5, page 59. A Court of Appeal case from 2009 in which there had been a settlement embodied in a consent order of the court in a personal injury case. The basis of the settlement being that the claimant would be cared for in the local authority group home, but then circumstances changed and a decision was taken to care for the claimant in private accommodation, which increased the cost. Application made to reopen the prior order. Judge says no. Court of Appeal dismisses the appeal. Now, one of the curiosities of Rult is that the head note is inaccurate, or at least is taken to be inaccurate, because if you look at the head note in the law report and read down, you'll see after the first semicolon there the following phrase, but that rule 3.17 did not apply to a final order disposing of the case, whether in whole or in parts. It's not what the relevant part of Lord Justice Hughes' judgment says, as has been pointed out by judges down the line. If I can ask you please to go...
I haven't found that rule.
That...
A semicolon where?
Oh, 5 or 6 lines into the held part on the head note.
Got it,
That's
thank
a G,
you.
yeah.
Yeah.
Does my lord see that?
Yeah.
So obviously the focus of the case was on interlocutory or procedural orders. But Lord Justice Hughes then went on to discuss final orders, obiter, obviously. It's just that he didn't say, or the natural reading of paragraph 15 of the judgment isn't that summarised in that head note. That has been pointed out since. And if I can ask you please to go to paragraph 15, over on page 65, and read that through. It's a long paragraph, but... And Mr. Cribbage pointed out that I misspoke a short while ago. This was a case of a final order. The special feature of it is it was a settlement agreement of a protected person, and you'll see that featuring in the submission, in this analysis, that follows. What I meant to say was the first part of paragraph 15 itself, which is the critical paragraph, is focusing on the case law that deals with interlocutory or procedural orders and saying that it's not confined to that. You then see, round about the H part in paragraph 15, a distillation of the circumstances which apply in those cases, case management decisions, which in a sense are right before adjusting down the line, if I can put it like that, namely Roman 1, erroneous information at the relevant time, Roman 2, subsequent events destroying the basis, sometimes described as falsifying the basis of the order. It's then that Lord Justice Hughes goes on to say, well, the fact that you've got those examples might not be enough, and it certainly won't be enough in the case of a final order, and it certainly won't be enough in the case of a settlement of a personal injury case of this kind, and that's the last part of paragraph 15. What's interesting, however, to contextualise that is what is also said in 16 and 17, where it is made quite clear that settlements of personal injury claims for protected persons deserve special protection from the court, because the whole policy of avoiding future litigation and the stress around that, where you're dealing with a protected person. So in a sense, they're more sacrosanct than normal final orders. I'm not saying that affects what is actually said here, but it certainly supplies the ratio. So paragraphs 16 to 19, in a sense, deal with that aspect of this case. But it's paragraph 15 that is quoted often for at least the acceptance in principle that CPR 3.1 small 7 can apply to final orders. There's no real guidance given because it's a negative form of guidance, as you'll appreciate.
I mean, it's dealing with a completely different situation.
It's dealing with a situation that's harder to unwind, yes, and indeed reopen. Again, it's a reopening situation because it's saying the settlement agreement enshrined in the consent order that records the financial basis on which this protected person will be provided for their future life.
Yeah.
The basis is gone, and therefore we want to reopen it and have a different order. So it's invasive. It's going to run up against the policy of finality, isn't it?
Yeah.
That's all I was going to show you for that, but with my comment that there's no real guidance in there on how to apply CPR 3.17 to final orders. It's because it's expressed in a negative sense, saying, well, this won't be enough. It won't be enough to show change of circumstance, etc. The next one is Terry, which is tab 8, page 107. I hinted earlier at this case, and of course, my lord, the Master of the Rolls, was in this in a prior capacity of his. The judgment was given by Lord Justice Hamlin, as he then was. And this is a case where default judgment had been entered. You can see this from paragraph 12. It doesn't matter for our purposes what it was about, the case, I don't think. Default judgment entered, an attempt to set that aside, dismissed, and an attempt to appeal that dismissal of the set-aside itself failed. Later discovery of an alleged fraud, that's paragraphs 17 and 18. So the defendant, who at this stage is a judgment debtor, later discovers grounds for alleging that the whole litigation is fraudulent. It's all part of a fraudulent scheme, and seeks to either strike it out as an abusive process or have the default judgment set aside, revoked under 3.17, and both fail. You see the impetus there described in 17 and 18. What you then get is a summary of the issues of paragraph 24. And it's the first two issues that matter, and for today's purposes, it's the second issue that really matters. You'll also see the origins, for what it's worth, of the CPR 3.17 point in paragraph 22. That it was the Lord Justice Gloucester on paper that raised that as a possibility. But what you then see in paragraphs 25 through to 40 is a discussion of the mechanism that is available for setting aside a prior judgment by fraud, namely the fresh action. So that is discussed. That mechanism exists, and what is then said in paragraph 40 is important, because in a sense it's an articulation of the broader point here. If there is another mechanism available, that forms part of the essential context for construing the power, this particular power. So that's the broad point. You then have the strikeout dealt with as issue 1 in paragraphs 41 to 67. We needn't concern ourselves with that, but the culmination of that is paragraph 67. Over on page 122, for all these reasons, we agree with the judge that the stated basis of the application to strike out does not support or justify such an application, nor has any authority. In these circumstances, we agree with her conclusion that she had no jurisdiction. So strikeout doesn't work. And then you move to issue 2. Can you use CPR 3.17 to do it? That runs from 68 through to 81, you have the citation from Tibbles at 72, albeit a truncated citation of that paragraph 39 of Lord Justice Ricks that I showed you, with an emphasis through those extractions on the non-exhaustive definition philosophy that should be applied here, which makes total sense. And then at 73, you can pick it up, that curtailment of the apparently open discretion goes no further in relation to final orders, in relation to final orders, and then you get the citation to Rult, the full quotation from Lord Justice Hughes' paragraph 15 that I showed you, followed by an extract from Mr. Justice Briggs, as he then was, in Kojima, which I wasn't going to look at, but that picks up the head note point. If you see there the quotation from paragraph 29, Kojima at the bottom of page 124. It says, first, although Mr. Stone has in his favour the description in its head note, I do not read the judgment of Hughes LJ as going quite that far. So Mr. Justice Briggs didn't read paragraph 15 of Rult as saying what the head note after the semicolon said about it. And then you get paragraph 75, which is important, and we've sidebarred it. If the court could read that, please.
Yeah.
So again, you're going to be up against the importance of finality as it's in the 6th line, and examples are given, but from other parts of the CPR. So there's an example given from the non-attendance under CPR 39.3, and there's an example given in powers that are said to be akin to 3.17 in maintenance cases of Full and Frank. There's then the reference to Sharland and Sharland, which was attempted to be used in the matrimonial case in the Supreme Court, with the full citation in 76 from Lady Hale. And then in 77, the distinction saying, well, this is a case of ordinary civil proceedings, not maintenance, so that won't help you. And then you see that brought home in 78. You can't bring it in within either of those earlier identified examples that we saw in paragraph 75, the full and frank or the non-attendance. But of course, pausing there, Tibbles has told us, and Tibbles was cited by Lord Justice Hamlin earlier, that examples are just examples, and that the court should be wary of any exhaustive definition. So the fact that you can't bring it in with those two examples doesn't mean you couldn't in another case. It just doesn't work here. The real killer, if I can put it like that, is paragraph 79 and 80. And this is what the court in Vodafone picked up on, which is that, well, hold on a sec. Here, the final order was a default judgment. The CPR makes specific provision for setting aside default judgments. That was exhausted here and didn't work. So you can't use CPR 3.17 to do the work of another specific procedure or mechanism, or indeed to trespass upon that other specific procedure or mechanism. And then the conclusion, 81, and we don't need to look at the third issue because that was case management. Could we then please go to Vodafone, tab 10, page 145. This is 2 years ago, almost to the day. And as I described earlier, you had patent infringement proceedings running in parallel to revocation proceedings in the EPO. And so there was no attempt to stay the determination in the English court. It went through to final judgment on liability, a finding and a declaration of infringement, inquiries to damages and costs orders against the defendant. The defendant petitioned the Supreme Court, and the Supreme Court said, well, we're not going to look at permission until you see whether you can do something about the order in the Court of Appeal. And hence, the CPR 3.17 application came forward. And it didn't work. And the primary reason it didn't work is because Vodafone authored its own misfortune. Because it was entirely foreseeable when facing infringement proceedings that the patent that you were saying was invalid as as your defence, or one of your defences, might actually be revoked in the pending revocation proceedings. So why didn't you just ask for a stay? And as the problem is identified by Lord Justice Lewison in paragraph 14, paragraph numbering is very small, the numbering itself in this report, page 149. And as posited as what, if anything, can or should this court now do about it? You see the provisions themselves, the two rival provisions, if I can put it like that, set out at the top of the next page. And I did just want to pick up on a textual point raised by way of observation by Mr. Sebastian in this context, under the rule we're looking at. So if you're looking at CPR 3.1 small 7, at the top of page 150, Mr. Sebastian points out the phrase, the words within the rule, under these rules. It has the power of the court under these rules to make an order. Includes a power to vary or revoke the order. And I think he takes the point, well, the order in question here was an anti-suit order made pursuant to the power in section 37 of the 1981 Act. And he's right about that in the sense of that being the court's power to injunct, to grant a remedy. But it's still in an order made under the CPR, because all orders are made under the CPR. You can't, as I'm aware of, make an order other than within the auspices of the CPR. So our order here, the target of the present application, is an order made under the rules, and therefore the power, this court has the power to determine whether it should be revoked or varied. That's the textual point. We can skip ahead to paragraph 31, because paragraphs 31 to 34 lay out all that was wrong, if I can put it like that, in Vodafone's approach to its procedural pickle. Essentially, it never saw a stay of the action, and it never saw a stay of the appeal. And to make matters worse over the page, having not done that and lost, it could still have asked for an adjournment of the question of costs, because it was the cost order that was the focus of the attempt to change the outcome. Mm. And you see then that being brought back in at the far end of the reasoning. In other words, you brought this on yourself, and that goes back to that broad theme I was describing earlier by reference to the authorities. You see the heading there, CPR Rule 3.17, and that section runs through to paragraph 56. You see the citation of Rult and Lord Justice Hughes' paragraph 15 again. You then see an important paragraph 38, which we've sidebarred over on page 155, distinguishing Rult, because in Rult, that was the care home case, but there was a, quote, incontrovertible fact subsequent to judgment, whereas, look at the last sentence of 38, it was quite clear here that what the EPO revocation of the relevant patent was entirely foreseeable. So Vodafone brought this on itself. You then get the citation to Kojamar, Mr. Justice Briggs, and again, the head note point there that we saw before. Then Terry, paragraph 75, which I showed you. And then interestingly, there's the quotation of paragraph 80 from Terry over the page in paragraph 44, picking up the default judgment CPR 13.3 point. And that's set out, which tells you that this Court of Appeal in Vodafone regarded that as an important part of the reasoning in Terry, i.e. what I would call the availability of an alternative specific mechanism. And then interestingly, paragraph 45 starts with the phrase conformably with that approach. Those are interesting words, because that is telling you that what this Court of Appeal took from Terry, as I've just described, is the available alternative specific mechanism point. Then you see the debate running through Gregory, which is in the bundle, via McWilliams and Karadigjian, if I pronounced it correctly, where this Court of Appeal we're looking at here ascertained a slight disagreement of view between two Court of Appeal benches in McWilliam and Karadigjian, and resolved it in paragraph 52 to prefer Karadigjian. Now, the thumbnail summary of that is, as stated earlier, if you are seeking to reopen an order, you have to go through 52.30. If you do choose to go through 3.17 as a parallel jurisdiction, you can't circumvent 52.30. you have to tick those boxes and those high hurdles. And that's what that debate is about. And then you get 53, the discussion of whether sealing of the order makes any difference, the citation to Ray, L and B, and also the Nigeria airports case at the bottom there, the Supreme Court case that Mr. Sebastian has cited. And paragraph 54 as sidebarred is then the one we rely on. The overwhelming thrust of the authorities is that the court's power under this provision to vary or revoke orders either cannot or should not be used to discharge a sealed final order. The only limited exception thus far even contemplated in civil proceedings is the case of a continuing order such as a final injunction. As it happens, that is obviously the situation that we are in, albeit we're before the court in unique circumstances. There is then, just for completeness, a discussion about the availability of 52.30 in that case, but there was no application to that effect. And the discussion was about the prospects of the Supreme Court giving permission to appeal and whether that was involved the exhaustion of an available alternative remedy, which is the third limb of that test.
Can I just ask, just to be clear, when Lord Justice Lewison says in 54, thus far even contemplated, what is he specifically referring to there?
I don't know, as it happens, because I've looked hard to find what that is a reference to, or rather, we both have, myself and Mr. Cribben, not found it. To hazard a guess, which is always dangerous, he could be taking what Lord Justice Hughes said in paragraph 15 about continuing interlocutory injunctions and just extrapolated it to interlocutory final injunctions on the basis that they are, in this sense, comparable because they have continuing effect. So let's say there was a final injunction that party A had to maintain a party wall. A had to maintain a party wall with their neighbour, but let's say both buildings were destroyed. It fell off a cliff.
Or one sold the property to the other.
Oh yes.
And then they came along and said, by consent, we need to discharge this injunction.
So you could see. So in that sense, it doesn't matter whether it's final or interlocutory.
This is terribly how many angels can stand on the point of a needle. There are countless examples where it is absolutely obvious that the court would accede to the both parties coming to the court and saying this final injunction is no longer necessary because there has been a massive change of circumstances. And we can dream them up until we're blue in the face.
Absolutely.
Terry, Vodafone, Volt are not dealing with that situation. And the fact that they found words which I would think fortuitously in paragraph 54 give you a leg in the door, even if they didn't give you that leg in the door, it wouldn't affect. It just goes to show the danger of trying for courts to try and draw general conclusions from the facts of a specific case. We have to be very careful. There are millions of different circumstances, and saying absolutely with finality that this conclusion applies to everything in the world is a dangerous and rather silly thing to do. So I'm not sure that's what they've done. I don't think they have. But you simply say, well, I can give you 20 examples of situations where you would obviously accede to such an application as I am now making, and therefore jurisdictionally there cannot be an absolute prohibition.
Well,
it's quite a different thing to say we ought to exercise.
I think in fairness what I've done so far, but I'll show you 3 first instance cases very quickly now. What I've done so far is show that all 3 times that the possibility of using 3.1 small 7 in relation to final orders has even been broached in the Court of Appeal, it's been left open as available as a power, even if coherent guidance hasn't been
I think we left it open in Terry, and we certainly left it open in Vodafone.
Yes.
On a slightly more limited basis.
Yeah, those being 2 of the 3 that I showed you.
Yes.
Absolutely.
Anyway, let's see the other 3.
The others are first instance. If you go please to tab 6, page 69. It's a case called Simmons, a decision of Mr. Justice Leggett, as he then was sitting in the Queen's Bench Division, rather than the Commercial Court on this occasion. There had been judgment entered on admissions on part only of the liability inquiry in a case, so it's going to go forward on other aspects of liability. Grounds arose subsequent to that judgment to strongly suggest, or indeed it was agreed, that the factual basis for those admissions was unsound, and therefore an application made by, I should say, by the defendant, so the loser, if I can put it like that, to have the judgment on admissions set aside.
Yeah.
And that's dealt with by the judge. So that was granted, and that's paragraphs 20 to 22, but principally paragraph 22 itself as sidebarred. The point being, you had the falsification of the basis of the judgment entered to a final judgment, albeit on part of the case. Falsification of the basis of the final judgment in circumstances where the issues dealt with in that falsified final judgment overlapped intrinsically with the stuff that was still live in the case going forward, and therefore justice demanded, if I can paraphrase, that the judgment be set aside and the whole thing went forward on a correct basis. Righting a wrong, as it were. That's all I wanted to show you in Simmons. The next two, one is called Madison, and the one after that is Ray Cabot. Madison is tab 2, page 17.
Yeah.
In this case, there were a series of judgments entered in favour of lenders on the basis or assumption that the consumer credit agreements in question were enforceable under statute, and it was later accepted that they weren't. So this is the first case we've looked at of where the beneficiary of the judgment, the claimant in this case, the beneficiary of that judgment comes back to court saying the right thing to do is get rid of those judgments because their basis has been falsified, in this case their legal basis rather than their factual basis. And you can get that from paragraphs 4 I think summarises how that arose, and then Mr. Justice Hilliard deals with the case, with his disposal of it at 46 to 48. And the two reasons given for that, the first one he says it's a truly exceptional case, in paragraph 46 in the middle there, and then his two reasons, or main reasons. The first is in paragraph 47, that these judgments had been entered administratively in block, is the phrase he uses, so they hadn't been the result of judicial evaluation.
I'm put in mind of the divorces that have been set aside when they've been entered by mistake on the digital system.
Ah, yes. Yes, as an analogy. So, so in a sense, you might say this feeds into the concept of finality, that this isn't, in a sense, frustrating any judicial expectations of an order staying in place, and we'll look at that in a short while.
Yeah.
So first point being administratively in block, they were put in place. Secondly being, well, it's the claimant, i.e. the beneficiary, who's asking for it to be removed, who's doing the right thing, as it were.
This is a never say never case, so yes.
Yeah. So that's paragraph 48. I should say that the discussion of the case law leading to that includes, back at paragraph 40, a decision of His Honour Judge Paul Matthews, sitting as a judge of the High Court in Prompt Motors. That's an example of a first instance case where the relevant judge said he didn't think CPR 3.17 did apply to final orders, save in cases of fraud. But it's something of an outlier. It's been pointed out by Mr. Sebastian, again rightly that he's pointed that out, but it's taken care of, as it were, it's considered by Mr. Justice Hilliard there. That is Madison. And then the final case I wanted to show you is Cabot, over in tab 3, page 29. Similar, factually, to the one we just looked at, in the sense that here you had 4,000 or so debts entered on credit cards, Capital One credit cards, after Capital One went under.
Yeah.
In favour of 3 separate claimants who'd taken assignments from Capital One. And if the court can please look at paragraph 2, paragraphs 2 and 3, you'll see that the impetus for the set-aside by the winning party, the claimants, was a dialogue with the FCA, where they were made to understand that the right thing to do would be to remove these judgments.
And everybody agreed.
Did.
Everybody agreed. See paragraph 2, last sentence.
Yes.
Yeah.
Yes, and if you go please to paragraph 6, you'll see Mr. Justice Mann then reasoning that through.
Yeah.
He's quoted Madison in paragraph 4, which is why you see the reference to Hilliard J in the first line of 6. And he says about 8 lines down, it would seem to me to be an extraordinary thing were the court to stand in the way of a person who seeks to unravel its own order. That's a phrase I've used today. Its own order, for an apparently good reason. He then goes on to consider what the apparently good reason is. Not good reason, just an apparently good reason. And it's that dialogue with the FCA. The judge has a side complaint in the rest of 6 and into 7, and he hasn't been told the whole story about that. So reading between the lines, in that last part of 6 and 7, read with 2, paragraph 2, you can see that the FCA let these claimants, these judgment creditors, know that they really ought to set aside these judgments against various consumers, 4,000 consumers. Now, I'm not saying we need a parallel or an analogue, but this is a case close to legal compulsion. You have a regulator telling a judgment creditor, or to put it in today's language, the beneficiary of an order, final order.
Well, none of this is binding on us.
No, absolutely not, no.
And it's, well, interesting to see the way Mr. Justice Mann put it there.
Yes, I'll say one more sentence about it before I finish, which is that Mr. Justice Mann wasn't concerned to look beyond the fact that there was that compulsion exercised on the judgment creditor to lift its own judgments. He was satisfied with an apparently good reason in circumstances where he was relatively convinced he hadn't been told the full story. But all I have to say is that the curiosity stops there, which may come back to our big theme. There's one other line of cases I was going to mention, and there's another case I can offer up, which is the notion of assisting the contemnor. This is in response to the court's question yesterday, which of course it is trite that even a party in contempt can be heard by the court without purging its contempt. That's something that is considered often in civil fraud litigation. We have a case in the Court of Appeal called Hin Pro International Logistics, a decision from April 2015. I know it's been considered in the Arbitrazh litigation, and Mr. Sebastian may want to say something about that. So the point being, the court always has a discretion.
What's the case called again?
We can hand out copies. It's Hin Pro, it's not in the bundle at the moment, Hin Pro International Logistics.
Impro.
Hin Pro, HIN-PRO. This is Compagnia Sudamericana de Baccarat.
Can you provide it electronically, please?
We shall do that, and Mr. Sebastian was given a copy this morning. But it doesn't say anything in a sense that isn't well known, which is the court always has a discretion to hear from a contemnor.
Yep.
And that is not even our situation here. You are not hearing from a contemnor here. You're hearing from an innocent party that wishes the...
Well, we may be hearing from a contemnor in a minute.
In a different sense. Yes, you're not being asked to accede to an application from a contemnor, which is the point. That's what I was using here from.
Yeah.
To me, that's the authorities. Can I say something about the public policies in play? And this will necessarily be brief and broad. 2 have been identified. The main one is the policy of finality and litigation. In my submission, the primary rationale, primary, not sole, for that policy in our court system operates on the private level. It's about closure, in the same way that our limitations regime works for stale claims, and in the same way that the abuse of process doctrine operates, and res judicata. It's about certainty and closure. If you litigate something through to a final order on a private level, you have an expectation that that's it. If you've got a monetary sum in your favour, you have an expectation you'll be able to use this court's or a foreign court's executory mechanism to get your hands on the cash. If you're a defendant and you've resisted it, you've resisted liability, you have an expectation you won't be vexed twice, or twice vexed is the phrase. So on the private level, that's the primary rationale for finality and litigation. And let's just test that here. Here, no private entity, even the litigants, is having their expectations frustrated, in the sense that the beneficiary of the order is back before the court asking for it to be revoked. So you're not taking something away from the bank that it doesn't want to be taken away. That's proven by the fact that it is here today seeking this application. But of course, that policy goes further. It also, in a sense, protects the court system from further use of its resource. In other words, when a final order is made, you can appeal it, sometimes out of time, or use all those other mechanisms that we've discussed when we've gone very quickly through the case law. The primary one being 52.30 zero if you seek to reopen it. And therefore that pushes CPR 3.17 very much into this residual position that it occupies, where nothing else applies, and you are literally using it to avoid an injustice arising, like I say, from the existence of a prior court order. It might be said that there is a waste of cure resources underpinning the finality policy. In other words, if you do go back and cancel a prior order, was all the judicial effort that led to it wasted? Test that here. It wouldn't, because you have both the Court of Appeal and indeed the Supreme Court's decision in this litigation standing, like I said, for what it says and contributing to the body of jurisprudence in this country, and no doubt looked at by others around the world. So there isn't waste in that sense, nor is there a frustration of judicial expectation.
And there is also an element inevitably of integrity of the system, not just use of resources, but that you aren't flip-flopping.
Yes, absolutely. And that, in a sense, dovetails into the second policy that's been identified, which is very much subsidiary, which is the integrity of the process and whether this process has been intermeddled with. And we've had the discussions that we've had around that. In my submission, if you translate that into our current position, you would not be allowing the English court process to be intermeddled with by the Russian court system if you accede to this litigant's application to revoke or vary its own prior order. I can use that phrase. Because you don't look further than the fact that it's this litigant before you asking for it to be revoked. The curiosity stops there, the inquiry stops there. Obviously, the policy of finality is going to weigh more with a final order than an interim order. That goes without saying. That's self-evident. And it is a weighing exercise, as Mr. Sebastian says. But in my submission, if you have the proof, the evidence of that risk of prejudice, an injustice that will flow if you don't accede to this order in whatever form you accede to it, then you're going to have an injustice caused by a court's prior order. My submission, and I can't put it any higher than that, that is the reason, or the apparently good reason, if you want to follow Mr. Justice Mann's language, the apparently good reason for allowing the beneficiary of the order to come back to the court in these circumstances and ask for it to be revoked. There has been no delay, and there have been no contributory element at all on the part of my client towards this state of affairs. It is wholly innocent in this. It tried to resist the position in Russia and it lost. And that is that. That's what I was going to say about public policy, and then it's just tying it all together. I'm not actually going to repeat what I said before. It's a wholly exceptional case. I don't shy from that at all. But we are not the authors of this misfortune. The bank is not the author of its misfortune. And critically, what that means in procedural terms is it has no other mechanism, and nor did it eschew any other mechanism historically, like Vodafone did. It got lumped with this situation, and as a result of that situation, it finds itself in where it is the innocent victim of someone else's behaviour. There is a new state of affairs which renders its own prior order a source of prejudice to itself in circumstances which were both unforeseen and nothing to do with it. And that is why it is before the court asking you to take this extraordinary step. And I don't shy from that. This is an extraordinary step born from extraordinary circumstances. And therefore, we invite you to accede to that in the interests of justice, to prevent an injustice, and not to look or feel the need to look beyond the party that you see in front of you, asking for what it's asking for. The circumstances in that sense don't matter, other than the fact that they are phenomenally rare. But the moralities and equities of another party's behaviour, the quality of another court system's decision-making just don't matter. They are the circumstances which deliver us to today. And the bank seeks this court's assistance in avoiding an injustice. Now, unless I can assist the court further, assuming I have so far, that's all I was proposing to say.
Thank you very much, Mr. Houseman. Mr. Sondor, do you want to make substantive submissions or not? Or are you content simply to associate yourself with all that you can properly associate yourself with in Mr. Houseman's submissions.
Thank you.
Hang on, we've got a bit of a bad line. Can you start again and try and speak loudly, because we haven't got great volume?
Yes, Your Lordship, I would like to make a short further submission. I think 5 to 8 minutes will be enough, and I would just supplement Mr. Houseman of what he's just submitted to the court, if that's possible.
Yep.
First of all, my lady, my lords, thank you very much for allowing my firm to make submissions on behalf of RCA. I recognise that this is rather an extraordinary, by all means. And even though I will occasionally refer to provisions of the English law, I should take note that I'm a member of the Russian law firm and therefore of limited assistance to the court. I have already taken the liberty of circulating 2 orders of the High Court in Deutsche Bank's case, which Your Lordship has asked.
Thank you. I've got them. I've got them and seen them. Thank you. And what they show is that Mr. Culver gave permission to discontinue, as he was entitled to do under the rules.
That is correct. And another order separately discharging the interim order in case there were any doubts of whether it survives and discontinues. I'm going to supplement Mr. Houseman on 3 points. First is the volition point. Second is the material change of circumstances for the purposes of this application, as RCA's view is that it might be neither the emergence of the Russian ASI order, nor it is the risk of UniCredit to be subject to the high penalty in Russia. That might be something different. I will address that briefly. And the third point is the public policy considerations or any countervailing factors that might militate against granting the application. Starting with the volition point, I would like to follow up on your Lordship's question in regard of the battle of the jurisdiction, since this is not the first time this court is faced since the West Tankers era of battling anti-suit injunctions and anti-suit injunctions, and that is exactly that case. An English court has issued an anti-suit injunction, and the Russian court has issued an anti-suit injunction, and therefore, at the end of the day, as your Lordship rightly emphasised, that will be up to one of the parties to stick to one of the orders and come to the requisite jurisdiction to comply with that order. And if the approach is taking that the volition, the consent of UniCredit to make this application is somehow undermined by the coercive power of the Russian order, that would mean that RCA could also never properly comply with an English ASI order in Russia, because then the Russian RCA's compliance would also be contingent and coerced by the English order, meaning that RCA's desire or consent to terminate proceedings, let's say, in Russia, is made under duress. So therefore, it is our respectful submission that it comes down to the parties' election, as Mr. Houseman has rightly noted that his own client's choice in this regard, and therefore that would enable the comprehensive and current commercial outline in the world where the conflicting judgments and orders that are directed against mutually directed against the parties, and the parties have to choose. And another point on the volition is that the the advocate for the Attorney General proposed that, well, that the court should not be disturbed because this could be easily done and then by the agreement between the parties not to enforce this very order. And then this begs the question, what's then the difference between this application and another agreement of between our client, RCA, and the UniCredit? That would genuinely raise the same questions. For instance, if UniCredit were not to follow that agreement, and whether when RCA would want to refer to that agreement, that would raise the same questions of law, whether UniCredit genuinely agreed and concluded that agreement not to enforce English antecedent injunctions, or whether any matters of English public policy would render that private agreement unenforceable. So therefore, that would be cause for further litigation between the parties, even though the consensual nature of that agreement would be even higher, because we admit that there is no prior agreement in writing, as your lordship indicated, that there might have been easier if the parties have space with the ICC arbitration clause in the bond. But this is the opportunity for the court to decide this once and for all, present application. And then it is RCA's position that the UniCredit is acting on its own volition in this regard. Going to the material change of circumstances, RCA respectfully submits that it is neither Russian ASI nor the risk of UniCredit to be subject to high penalty in Russia, which is the material change of circumstances. It is the fact that UniCredit and, in fact, other German banks, because the High Court is also looking and stayed its proceedings to see the outcome of the present proceedings, have they intend no longer to proceed the contractually agreed forum, the forum that has been contractually agreed in the bonds, and that is a material change of circumstances that neither UniCredit nor other German banks wish any longer for all of the disputes to be brought to Paris ICC. That is, however, as our client sees it, when we look at the confirmations of various German banks, including the UniCredit, that they intend to comply with the Russian ASI orders. And this is material, because that's not simply the risk, but that is a fact that has occurred after the English ASI order has been granted. And therefore, the proper test is rather different. A change in is material that if it had occurred prior to the ASI order is issued, then the no ASI order would have been granted. And in that sense, the Vodafone case at paragraph 38 might be upheld. Mr. Hausman already referred this court to that case. It's 145 to 159, and at paragraph 38, Lord Justice Gleeson says basically that in view submissions that exercise of the court's power under the CPR 3417 is engaged where there is an incontrovertible fact subsequent to the judgment which undermines the basis of that judgment. And I'd like to take it from that the fact that undermines the basis of the judgment. An ASI order, a court order, it is an order that enforces the FATSA's contractual obligations, and that's been confirmed by in paragraph 90 of the Supreme Court, in this case by Lord Leggett. There's just to give it another negative promise not to bring court proceedings contained in the arbitration agreement, regardless of whether arbitration proceedings are in existence or unpaid. So, therefore, if it's merely enforcing a contractual right not to be sued elsewhere, And if the court had been aware, or that fact had emerged that UniCredit has waived that right and no longer perceives that contractually agreed forum, no longer wishes that all the disputes should be brought to Paris, then that application would have failed, and therefore this fact undermines the basis of the judgment, and therefore it is a material change of circumstances. I recognise that this is because of the Russian ASI order, but that might be a motive for the UniCredit, not the cause, not the fact itself. The fact itself that the UniCredit elected to comply with the Russian ASI order and therefore abandon its contractually agreed forum, and therefore the present anti-suit injunction, the essence of that injunction, that coerces RCA to bring all of the disputes to Paris under the threat of the contempt of the court proceedings. Well, to put it lightly, it is now quite, it bears no logic, since UniCredit no longer wishes RCA to bring all the disputes in Paris. In fact, UniCredit actively participates in the proceedings in Russia, appealing both ASI order and the judgment on the merits in relation to the merits of the case. And if you could see tab 13, where the Russian ASI order is placed on page 117 to 118, on those two pages, tab 13, the operative part of the Russian ASI order is contained, and paragraph 1 and paragraph 4 of this order also say that the UniCredit is prohibited from instigating proceedings elsewhere apart from the course of Russia. And it seems to RCA that UniCredit has agreed to comply with those provisions of that same order that required UniCredit to take all the measures to revoke the English court order that we are discussing in these proceedings. So, to conclude on that point, applying the test that I've just described, the fact that UniCredit has waived its rights under the arbitration agreement and no longer wishes to pursue contractually agreed forum undermines the 27th January order, and had this fact occurred before the order had been made, no order would have been made. And turning to the last point of public policy considerations, I should start with explaining the question that have already arisen by the advocate to the court and by your lordships, that whether Russian court order compels the UniCredit to take all the measures, or the Russian court order penalizes somehow UniCredit for the actions of the English court, for instance, if this application is not satisfied. And I admit that the letter of LE that has been submitted to this court looked quite inconsistent with the previous submissions that have been made in this regard. And I would like to clarify that Mr. Hausman rightly referred your lordships to the tab 32, page 255, paragraphs 15 to 18, or where the RCA's application to amend is contained. And it is right to say that over the course of the Russian proceedings, RCA never contended that UniCredit has to procure certain result of this application. That's inevitably the discretion of this court, and the same rules apply to the Russian courts. I mean, the committee rules that the Russian courts can never direct English courts to come to any certain conclusion. I make myself clear on that, since the Advocate Attorney General pointed that out, that if the Russian court would indeed penalize UniCredit for the English court's decision, that will be akin to sanctions, not the anti-suit injunctions or injunctions in private law, as we usually see. That is not the case. In this regard, the last point on the applicability of Russian ASI order is that in this, at the same page 255 at tab 32, in paragraph 18, RCA quotes a similar court order, Russian court order in relation to Deutsche Bank, and I'd like to quote what that order says, that thus the applicant requests to oblige to submit the relevant withdrawals within 2 weeks from the date the court order comes into legal force, but does not request to ensure such a result as determination of the proceedings by the court within the specified period. It is obvious that the relevant issue of accepting with the withdrawal of applications will be under considerations by the relevant court, and that should give some comfort to the UniCredit and this court that it is indeed the case that Russian ASI is directed with UniCredit only. And to supplement on the public policy in the interest of finality, on this point, we note that this is an application by UniCredit with the consent of RCA, and the granting of this application would not be condemning RCA's behavior in this regard, because as I described previously, that would leave the parties in a hopeless situation. What if the parties have concluded previously, well, indeed, that there's been an order of the English court that has been breached, but it is a private matter, and subsequently parties reach the settlement or whatever terms parties can agree. And that would mean if this application could not be granted on allegedly condemning RCA's previous behavior, that would mean that no settlement between RCA and UniCredit is possible in the future at all. And in this regard, I agree with the submissions of Mr. Houseman that the finality itself is not self-standard reason to refuse an application such as this one. The criteria, as eloquently outlined by Mr. Houseman, are met. And lastly, I'd like to address the alleged no benefit of RCA as put by the advocate to the court. Here, in order not to be repetitive, I would like to say that it is in RCA's best interest to have an order that requires RCA to bring all the disputes to Paris, even though UniCredit no longer wishes to bring those disputes to Paris under the threat of the contempt of the court to be removed. That will be in line with the parties' agreement and the changed circumstances, namely that the UniCredit no longer wishes all of the disputes to be brought to Paris. Thank you very much, my lady, my lords, if I can be of any further assistance to the court.
Thank you very much, Mr. Sondor. Now, Mr. Sebastian, if you wanted to take 2 minutes to tell us how you're going to approach the matter, you may, or if you'd like to keep your powder dry until 2 o'clock, you can do that too.
I'd rather keep my powder dry.
2 o'clock it is.
What, right, okay, cool.
consent